Hi everyone, my name is Nicole Bowden and I am a paralegal, and I'm going to talk to you today about a motor vehicle accident case and what to do when you're in one. The first thing I want to talk to you about is that you're going to have a two-part case. The first part is going to be the actual damage of the car. So the insurance company is going to require you to either get an estimate of the car or they will mark it as a total loss. The estimate of the car is done normally within 48 hours after the accident. So what they do is they will have somebody come out, look at the car, assess the damage, and they will either total out the car or issue you a diminished value check. If they total out the car, they're only going to give you the value of the of the car. And so what this will do, if you owe $10,000 on the car and your car is only worth $8,000, you're only going to get that $8,000. It's going to be up to you to pay off the rest of that too. They can try to recoup that at the personal injury case, or you're going to have to come out of pocket for it. And then the second part of the case is just the personal injury. The first thing you want to do is choose a reputable attorney. Consumer Reports published an article called When You Need to Lawyer Up. And these are the type of cases that you need to lawyer up. The best way to find an attorney is to go through the website or call the American Bar Association. They have a list of attorneys and what their area of expertise is. The other way is the way that I recommend, and that's through word of mouth. You want to ask your friends, your family, find out a reputable attorney, understand how they deal, who you're going to deal with at the law firm. Normally it's going to be a paralegal. Once you find a reputable attorney, you're going to want to sign the retainer. Dolores Dorsaville says, "Get it right, retainer agreement, do's and don'ts." And in this article that she published, you want to look for two things: the scope of the work and the terms of payment. The scope of the work is what we're going to cover. Let's say that we're going to work up through the demand. If we have to go to trial, then it's probably going to be a different fee. That brings us to the next topic, which is our contingency fee. According to Andrew Myers, in his article, What to Know About Contingency Fee in Personal Injury Cases, he says that the normal contingency fee is 33%. We work on a 33 1/3% through the demand. If we have to go to trial, it will be 45%. The next thing you're going to sign is a HIPAA release form. And the HIPAA release form is for us to request medical records on your behalf. The next thing you'll sign is an authorization, and this allows us to request the at-fault party's insurance policy limits. Once all these documents have been signed, we'll get to work. So the first thing we do is send out letters of rep to the at-fault party's the at-fault party's insurance, and then your insurance. According to OCGA 33-3-28, they have 60 days to respond to us with the insurance policy limits. Once we do that, we request your medical records. Now, we will only request your medical records after you have completed treatment. This treatment may include specialists, ER visits, psychology visits, but once you're done finished treating, that's when we'll go ahead and request those records. Now, this can take anywhere from 60 to 90 days. So there is a time frame that we're going to be working with. This case does not happen overnight. The next thing, once our medical records are requested, we'll work on your demand. Now, the demand gets sent to the insurance company. The demand will include the history of you, your accident, and we'll do a thorough identification of your accident, and it'll include the medical records. According to Brian McCarthy, Medical Evidence in Litigation, the medical records paints a picture as to what happened in the accident. And we're going to ask for the full policy limit. Now, Georgia requires that the policy limit be at least $25,000. So that's what we're going to demand. Next, we'll do negotiations. Either the insurance company will give us the full 25,000 or whatever your policy limit is, or they'll come back with a lower number. If they come back with a lower number, we'll contact our client and make sure they agree to it. And normally we will not accept a lower number unless they sign a document stating that we can accept that on their behalf. Once we come to an agreement, we receive a settlement statement from the insurance company along with a check. The check will be made payable to the law firm and the client. Once we receive that check, we deposit it into our account, and then we write a settlement statement for the client. And that settlement statement includes the settlement amount, our attorney's fees, our expenses, which could include requesting records or mailings, things like that, and then the amount that's due to the client. And they will sign that settlement statement and we will issue their check. As you can see, there is a lot of work that goes into these types of cases. These type of cases do not happen overnight. They can take anywhere from three months to a year. It just depends on the severity of the case. Now you know what to do if you're ever involved in a car accident. And if you're ever involved in a car accident, you'll know what to expect. I am asked a lot of questions, and normally the most question that I'm asked often is, how long is this case going to take? Will I get my money right away? It's not going to happen. It's going to take time. And then they also want to know what our fees are. A lot of people are upset at our fees. They think it's too high, but there's a lot of work that goes into the case. Thank you for your time, and I appreciate your attention.